Okay, this is Diesel for We the People. Alright, so this is going to be part 3. And I did a couple of videos on this so you guys kind of get an idea. And give a little bit more details of what the courts are doing. So that way you can understand. Now, I'm not an attorney. This is a learning deal for we the people to challenge the jurisdiction of the courts or anything else to protect us from the outforce necessary that bringing harm to us. There's not really a whole lot else I need to just explain because I explained it everything on the other videos, but this is just to cover my butt on YouTube and any other venue. This is actually the beginning of the court proceedings, and the reason why I did the other 2 videos again is to see what the attorney and him was talking about and pay attention to what the judge is saying and how they are curveballing everything and trying to entrap you into their domain.
We'll go back to the cases that we missed. Are we ready to deal with State versus Estabrook?
I believe so, Your Honor. Thank you.
Okay.
And for the record, Your Honor, Jenna Plank, representing the state, spelled Jennaplank. Seated beside him is Mr. Estabrook. He would please speak.
My name's Robbie.
Mr. Estabrook, as my understanding, is here pro se.
P.S. So if they're not licensed by the state and they're only by the bar union itself, right? So how do they actually have any authority whatsoever if the states cannot intervene in this, right? They got free reign to do what they wish. And that basically what they're saying is the states don't have jurisdiction over the bar union. And the bar union is judges and attorneys. So that enhances the bar unions investigate themselves, and states really cannot do anything about it. Does that make sense to you?
Your Honor, the state has dates that work. I attempted to have some discussion with Mr. Estabrook. I believe that these dates don't necessarily not work for him. The trial dates that the state would like would be call Thursday 8/18 for trial, Monday 8/22. If that date is particularly overly large, the secondary request would be call 8/22 for trial 8/23.
Well, we should be able to do it on 8/22.
I object to a trial at this time because I still intend to plead guilty, like I've been attempting to do the whole time. For some reason, I have been prevented from entering a plea. I have not yet been arraigned, and I don't know why this has been drawn out as long as it has. I believe that your record will indicate that I have been arraigned, but I have not ever at any point entered a knowing and voluntary plea. I'm just wondering if I have the right to enter an informed plea.
Well, we show an arraignment on March 1, 2016.
As I said, that is incorrect on that date. Do your records indicate that I made a knowing and voluntary plea? Do I have the right to plead guilty today?
Just a moment. Of course you can, but we're going to have to do some paperwork, and it might be. I just wanted to clear up the initial question: was he been arraigned? And it shows that you were arraigned on 3/1/2016 before Judge
show how the arraignment happened?
In, let's see. Looks like Justice Center, and he signed it. It says under duress and threat of violence, but nevertheless, you acknowledged it, and Floyd Place ordered you not have contact with victims, and ordered to appear on the 16th, East County Courthouse.
I've made it pretty clear on the record that all I've been trying to do is plead guilty. I'm simply attempting to make an informed
If you've done the paperwork, we can take a look at it here. Otherwise, I'll just send it over to CPC for a plea.
Do I have the right to make an informed plea today?
We have, see these pleas on the board? All of those have all the paperwork already done for them. I have those, I should take those. If you haven't, we can give you the forms, and you can go through them.
I'm going to pause there for a second. So during the beginning of this, right, what happened was the judge entered the plea, which cause and effect forced him in jurisdiction. But since the judge cannot enter a plea lawfully, well, now she's kind of stuck. She's like, what am I going to do? Because she stayed silent. She's reading the paperwork. Number one, she should have already read all this anyway, and at least had an idea what was going to happen in this court. She decided to do this at the last minute. The time essence on this was of her negligence. Okay? So he could not be arraigned without him voluntarily giving consent of the jurisdiction. So he was forced into jurisdiction unlawfully. And now she's stuck because she's recognizing that this judge did something unlawful. But how is she going to do this? Well, this is what she's trying to figure out. Since this judge did something unlawfully, how do we proceed forward on this matter right now, since there is no jurisdiction?
If you get them done before we have to move on, that's fine. Otherwise, I'll just send you to the CPC court, which is up in Fifth Ward.
I really do not wish to have to continue coming here. Each time I come here, I'm threatened and told that if I don't show up, then
You can, I would imagine that they can.
P.S. When he did sign the paper, it was under duress. They cannot be entered in the courts. It cannot be held against him. It was under duress. This is just common knowledge, 100%. If you've been tortured and you give out information to be released from being tortured, well, that was under duress, right? So the courts cannot accept that, and yet they're trying to still proceed forward under the duress part, which again, she's stuck. Well, you acknowledge the fact because you signed it under duress. Well, that's the reason why it's under duress, because I don't recognize it. I did this because I was forced into it. I did not consent or anything. And the fact is, whatever they threatened him with, they would have done it. It's been proven over and over and over, United States-wise, that the courts will forcefully do things against your will. It's just a fact.
take the plea today, if you can get the paperwork filled out. What I'm saying is that there's paperwork, we'll give you the forms, you can just settle down and work on them. If we can take them here after you've gone through all of that, and I can take the plea, I'll take the plea, otherwise we'll send you upstairs.
Am I entitled to responses to clarifications that I have regarding the cause and nature of these proceedings?
I told you what the proceeding is, you have been arraigned.
Objection. I have not been arraigned at this point, and
No, our records show that you have. All that arraignment is that you get orders when you next appear, and you get given the accusatory instrument, which reflects that you did. So that's the arraignment.
has the prosecutor submitted evidence establishing jurisdiction?
There is no. That's not the part of the proceedings. That's not arraignment.
Well,
Arraignment is not evidentiary.
objection, point of clarification. I'm not asking about evidence for the hearing. I'm asking if the prosecutor has met her burden of proof and established jurisdiction so that we can proceed with the matter. I'm wondering why it is that you have the right to adjudicate this matter and why I do not, and whether or not you're assuming jurisdiction in this matter.
I have jurisdiction. I have taken an oath of office. I have been installed as a judge in the court of general jurisdiction in this jurisdiction. I have jurisdiction over criminal matters. I assure you that that has been done. It does not have to be reestablished for each proceedings. And I think I've handled the issues here. I'll give you the paperwork for a plea. I'll ask you to step aside so we can continue with the proceedings.
Point of clarification, are you saying that
He's given the paperwork.
Are you saying that the rules are applicable to me and that the prosecutor has given evidence establishing that these rules are applicable to me that you're charging me with?
All rules are applicable to you. They're applicable to other people in this courtroom. You're not special. I don't have to establish the whole range of the laws of the state of Oregon, the laws of this country, the Constitution of the state of Oregon, the Constitution of the United States. I don't have to do that for you individually. It has appeared in the court file that you have been arraigned, and we're just going to proceed that way.
Objection.
Okay, she don't have to prove anything. Yeah, I mean, you threaten to put him in jail. So what is the just cause? What is the factual evidence that you actually have this authority? Well, if you can't prove it, then it does not stand as facts. That's just the way it is. This is the reason why you are guilty until proven innocent, because they keep railroading you and keep making up stuff to put you under bondage. And then they don't have to prove that they actually had this. Well, then where's your authority? Where's your evidence? And where's your factual proof that you actually have authority? Remember, when you enter there, and if you're innocent, as of that point in time right now, you are above them, because they have no authority over you. They only have authority of factual just cause. There's not even been an argument yet, because it cannot be an argument, because he sat there and actually said he was willing to enter a plea. But there's keep on saying that they don't have to do this and don't have to do that. Enhances innocent people go to prison.
I understand that you've objected. I don't need to continue this dialogue.
Is that an opinion that you're relying on?
Step aside.
Is that an opinion, or are you relying on facts and evidence?
I am telling you that we have concluded your portion here.
So
He planed out totem. Is this, but she bypassed the question. What evidence? She's not going to answer because she has absolutely zero.
Saying the prosecutor has submitted evidence establishing jurisdiction.
I am telling you that the prosecutor does not have to submit any evidence where we know who the prosecutor is, and it is not going to be a special proceedings or special process for you alone. Now, you have been arraigned. You say you want to plead. I've given you the paperwork. You haven't filled it out yet. I'm going to ask you to step aside so we can continue with this proceedings. Actually, I'm going to order you to step aside now.
Madam, may I use your jury room?
Pardon?
May I use your jury room?
You may.
Thank you.
Okay. Well, I feel like I'm being threatened, so I will go.
Okay. Again, it was an order, and yet she has no authority. She has not never entered the jurisdiction. So she has no authority over this man. Or showed just cause. Or controversy. This is it for this video.